Hello, I'm Victoria Green. I'm a senior barrister at 1KBW. I practice exclusively in children law, undertaking both public and private law children cases with many years of experience in both of those areas. I'm sat here today with Victoria Halsall as part of our 1KBW Go Beyond the Threshold series. Um, Victoria is going to be talking about the issues around drug addiction and how that is dealt with and fits within the PLO process. In particular, questions of where we have parents who have drug and alcohol issues, whether they are effectively doomed from the start, or whether the system is struggling to strike the right balance between protecting children and allowing parents a meaningful opportunity to change. It's an issue that sits at the heart of many public law cases. It raises questions about risk, delay, fairness, and the extent to which decision making can or should accommodate recovery and relapse without drifting into social engineering. So I'm very pleased to introduce Victoria Horsall today. As I say, she will be dealing with this topic. She has got experience across all areas of family law and public law children proceedings. She's been involved in a wide range of cases, including those involving neglect, domestic abuse, substance misuse, allegations of child sexual abuse. We, in fact, have acted together not too long ago in the case of RE. We together represented the local authority in what were very long, complex care proceedings that had followed on from some abduction proceedings. So thank you, Victoria.
Thank you very much. The first thing that I think people should be aware of is the issue of substance misuse is more prevalent than people might think. The research undertaken in 2020 shows that about 478,000 children, or approximately 4%, live with a parent who has either problematic drug or alcohol use. And in child in need cases, parental drug use is around 17% and alcohol use at 16%. It's something that, of course, is correlated with risk, and particularly with neglect and harm, cumulative harm, but it's not something that is determinative. And the presence of drug and alcohol, particularly within care proceedings, can often be a very dominant narrative. And that can be entirely appropriate, but it can also be somewhat reductive and used as a means to, in some cases, vilify parents in that situation. Now, I won't go through and summarise what the public law 26-week window and how it works in practice is. Practitioners will no doubt know, and it is often honoured as much in the breach as it is complied with. But regardless of the specific length of proceedings, delay is something that is at the forefront of all practitioners' minds and all judges' minds when we start such proceedings. Now, for some issues, that 26-week window may be sufficient to see whether certain issues can be resolved. If there are issues of general neglect, work can be done to put matters in place to make, for example, the home conditions more appropriate and to see whether that can be sustained. But drug and alcohol issues are something that are very different. They are effectively illnesses and addiction rather than character flaws within an individual that can be neatly resolved. Now, recovery does not fit within a 26-week window. Sustained abstinence, relapse cycles, behavioural changes, that all requires a much longer term intervention. And many parents enter proceedings at a late stage where those issues can be particularly entrenched. Those issues are also related not only to simple drug and alcohol misuse, but issues of other vulnerabilities. They may have experienced their own trauma, domestic abuse, child sexual abuse, issues with cognition, issues with psychology. All of those feed into what I would say is a cacophony of issues that mean you can't simply fit drug and alcohol misuse into a neat window and resolve it in the way that ideally I'm sure the courts would like to do so. The research suggests that between 40 and 60% of those with issues may relapse in the first year. And that is a real risk because within a process that tries its hardest to fit within a 26-week window, these individuals are possibly not given the opportunities that are needed, particularly when a lot of the suggestions for intervention will already come midway down the process. Recommendations coming from, for example, parenting assessments will often come 14, 16, 18 weeks into the process. And at that point, when it said they need to undertake a sustained period of recovery work and then shown abstinence, it doesn't fit within that suggestion that this can be resolved. Now, delay, of course, is something that does cause a problem with drifts in care planning. It does cause emotional harm and instability for children, particularly if they're not placed within the family. But that is something that does have to be balanced, and very carefully balanced, against not only the rights, for example, to family life, but also to the relative potential lack of permanence that any permanency placement may have. We will all be aware of the risks of foster parents not keeping children on, placements breaking down, and even in more secure care planning of special guardianship and adoptions. Those are by no means ones that are not fraught with their own difficulties. You also have to consider for children the psychological impact of whether they are placed with a parent or not and how that relationship will change, because those are issues that are going to impact them not just in their childhood but throughout their adult lives. Now, the court has tried to some extent to grapple with this, and no doubt many practitioners will have experience of the FDAC process, and that was designed to be a more systematic, therapeutic and problem-solving intervention with a multidisciplinary team rather than an adversarial system. And the research into FDAC is positive. It suggests much higher rates of reunification and a much more stable home environment for children when it does work. At the moment, however, there are only 14 FDAC teams still operating, and a number of the FDAC programmes, Somerset, Kent, Cardiff, North East, they have had to close due to funding and resources issues. So it does beg the question of, on those short-term issues of funding, which permeates a lot of the work that local authorities do, as to whether longer term we are ending up in a position where more money is spent because these interventions haven't been successful. Now, when we talk about whether parents are doomed, the question is effectively, are decisions being made that look at them and predetermine assumptions about their lifestyles and the prognosis that they're likely to have? And that comes with a number of difficulties. The first being the courts having to assess risk of relapse, which is a probability and not a certainty, looking at the insight and the likelihood of sustained change, but also reliance on expert evidence and looking, for example, at calling usage high, medium, low, and not looking at the contextual data behind that, how that's working for a family in practice, and whether the trajectory of movement is positive. Drugs and alcohol, as I say, are a symptom rather than a cause within these proceedings. And there needs to be a look, certainly in my view, at those other factors, because one of the other things we see is the drug and alcohol cases that come before the court are often those from a lower socioeconomic background who have these other issues. And I think we will all know as well, there will be parents of a higher socioeconomic background who drink every evening or will engage in recreational drug use. It's very rarely those cases that come before the court. And we really need to be very careful that we don't have a two-tier system where for those parents it's frowned upon, but it's allowed to happen and sort of get on with it. And meanwhile, parents of a lower socioeconomic background are almost punished for having these concerns, particularly when they will have a much greater chance of other vulnerabilities that need to be considered. Now, I don't think, and I don't say that parents are doomed in the system, but it is something that parents may think when they enter it. And one of the things we need to be very careful about as practitioners within the court system, but also wider in the public, in the local authority, is making sure parents don't feel they're being set up to fail. Because one of the things that is going to impact upon them is if they feel they have support rather than judgment when trying to get help. Because for those individuals, getting help can be incredibly scary. It requires not only an acceptance, but also an acknowledgement of a need to change. And that's hard enough for anybody, let alone somebody in that position. So there does need to be, in my view, a creative approach to it and a balanced approach. That early, the pre-proceedings intervention needs to be considered before positions have hardened. There needs to be realistic expectations of the timelines for this and not sacrificing justice at the altar of speed and acknowledging that in some circumstances parents do need a little bit longer, but that might lead in the medium to longer term to better outcomes for those children. There also needs to be creative thinking around integration between not just the hard and fast court proceedings, but the work going on in the background and how those multidisciplinary teams can work together and within an individual assessment of people rather than an assumption as to how they will respond based on generalities, because each individual is different and each individual will come with their own challenges and difficulties, but certainly something that can be worked with rather than worked again.
Is there an issue, though, Victoria, in terms of whether the PLO process is fundamentally incompatible with what a recovery process looks like?
Well, I don't think it has to be. I think if we had a system that said everything has to conclude within 26 weeks regardless, then we would be in real difficulties. But we will all have seen cases that have gone on for much longer than that. And part of the reason judges make those very sensible decisions is to allow that time. It has to turn on its own facts. If it's elevated to a requirement above everything else, we're in real difficulty. But it also depends on when the implementation of these changes and the support that is offered, when that happens. Because if that happens during a pre-proceeding stage, during the local authority's involvement either into child protection, you end up in a situation where a lot of that work can have started, and therefore that time frame when we get into court proceedings and the clock starts ticking, as it were, may be sufficient. It's far more unfair if that work only starts midway through and then that delay in them being offered those services is then used as a reason not to give further time. That's when the difficulties are here. And I'm very much not here to criticise social workers who do a fantastic job, but we need to have that creativity of thinking and that longer term view, particularly of resources, funding elements, but also the impact on children of these longer term decision making before we decide how to balance those competing factors.
I suppose one of the other issues, though, is about resources. I mean, for example, you were talking about FDAC and that FDAC has reduced in number and size, and there are limited resources. So is it really realistic, I suppose, to expect the system to provide the sort of level of support that's going to be needed for these parents to succeed?
It is, and it's one of those situations where it can be incredibly difficult because comparing the data can be almost impossible. But what we do know from the FDAC process is that individuals are likely to have greater stability, less chance of relapse, and more likely to have children in their care. And it's one of those situations that needs some long-term thinking because the short-term costs of those interventions may be much higher. But for example, the costs of keeping a child in long-term foster care and all of the, not just the care for them, but all of the additional provisions and the additional support they may need for dealing with the fact they're not with their parents, that all comes at significant longer-term cost. I mean, there are cases that fall apart for other reasons about funding not being able to offer, for example, special guardianship funds to special guardians. And then you end up with a child in foster care, which costs much more as you go. So we need to be looking at how this works. I mean, there's not an appetite, unsurprisingly, for reform because of the stigma around some of these issues. It's not something that any political party is going to come and say, this is the issue that needs resolving above all others. But it is something where resources are also not just about funding. And local authorities often have all of these resources or can signpost, but these parents with vulnerabilities will need help to access them. They may need support, for example, with other childcare or with getting there, things like that, which are not necessarily funding in themselves, but just require the individuals in the process to be thinking creatively about what is going to maximise the chance of these parents succeeding. It's not a perfect answer, and I don't claim to have the perfect answer, but it may cost more in the interim. It may end up longer term costing less. But even if it does cost more over the longer term to ensure this, someone needs to work out whether that is a cost that is worth bearing to maximise the chance of keeping a family together. It's not a one-size-fits-all approach. It's not something that anyone will be able to legislate what the right answer is. But if all practitioners and all those working in this professional environment are aware of it, then the hope is that we can try and work together to implement a system that is working best for the people within it.
Very much hope that you'll be able to join us again for the next session and indeed future sessions, which will continue to explore what we hope will be interesting and useful topics, challenging areas of public children law. Thank you.